Hello everyone, my name is Sanya Mahajan. I am a legal intern in a LEXCLIQ company, and today's topic of mine is contract law. And here we come to know about it is that it is a law or a rule which is made by authority for the proper functioning regulation of community or a society in law. The contract is a legal agreement. In other words, it is a promise or a set of promises which the law will enforce, and the agreement will create rights and obligations that may be enforced in the court. And the normal method of enforcement is an action for damages for breach of contract, though in some cases the court may order performance by the parties in default. There is a notion of free consent. The parties must have entered into an agreement that is freely, and the purpose of agreement must not be illegal or contrary to the public policy. Introduction to the contract law is here. As we all know, in our daily life we make many promises. Some we think it's binding and some not. But as per law, if anyone enters into a contract with another person, he is binding upon the parties to the contract, and it does not need to be infringed at any cost. Here is the definition of a contract which is mentioned under section 2H of Indian Contract Act 1872, that is, an agreement enforceable by law is a contract. That in a general sense it means a law of contract is a branch of law which determines the circumstances in which the promises are made by the parties to the contract and which shall be legally binding upon them. And each contract creates some duties and rights upon the parties to the contract which are to be binding upon them and which are to be enforced of such rights and duties upon the party. There are the two basic elements, or we can say it is a main element of a contract, that means agreement and a legal obligation. It creates a legal obligation for the parties to the contract and they are binding upon it. There are different types of contract. On the basis of formation, there is express contract, implied contract, quasi contract. On the basis of performance, it is executed contract and executory contract. On the basis of validity, valid contract, voidable contract, and void agreement, illegal agreement, and unenforceable contract. Contract formation. It can be only formed after the agreement is made between the parties, which provide a legal obligation to the parties by offer, acceptance, and consideration. For a valid contract, there is a need for the parties to be in a valid capacity. Persons who are not capable for contract are minors, person of unsound mind, person disqualified by law. And there is a mode of discharge in contract, that is by performance, by mutual agreement, by operation of law, by lapse of time, by material alteration, and by breach of contract. As we all know, the parties are binding by law in a contract. So if there is any infringement related to the contract, then the law has provided them with the remedies to the parties, that is rescission. They can file a suit for damages, they can file a suit for specific performance, they can file a suit for injunction process, and also suit for quantum merit. As here is the conclusion related to the contract law, that is basic important point. And we come to know that the parties to the contract or a person making any promise to another person is under a obligation as per the law, and he will get any punishment related to it, or if he does not complete his contract within a limited time period. This video is related to the contract law and for education purpose, and if you need any information related to it, please do write in a comment section, and please do subscribe this channel lexcliq.com.